welcome to my lecture on patent rights and its justification. In this lecture, I will be covering that why patent right is essential for the progress of science and technology, for development of new technology, and as well as why patent rights are necessary for the general public. Now, before I begin, this is my let us try to recollect what we have learned in the last class. In the last class, we have seen that property rights are in fact actually a bundle of rights, a bundle of entitlements to which the property owner is entitled to. We have seen, suppose a mobile phone owner, he has a set of entitlements which are recognized and protected by the legal system, like he does have the right to make a phone call, he has a right to sell the mobile phone, he has a right to destroy the mobile phone, and so on and so forth. And if we keep on writing the entitlements to which a mobile phone owner is entitled to, in our whole life we will not be able to write it down. But this similar feature we have seen that it is present in intellectual property. To be more specific, this is also present in copyright system, and this is also present in all other intellectual property branch, including the present study on which we are undertaken on patent law. Now, so far as patent right is concerned, actually that is embodied in enumerated in section 48 of the Patent Act, and it makes a distinction between product patent and process patent. And once I actually tell you what are the rights to which a patentee is entitled to, I will try to make a simple distinction. I will try to explain that what is process patent. Now, so far as product patent is concerned, read the line very carefully. It says that the exclusive right to prevent third parties from making, using, offering for sale or selling or importing the product in India. And when actually the patentee owns a process patent, he or she does have the exclusive right to prevent the third parties from using that process, and then from using, offering for sale, selling or importing the product obtained directly by that process. So, here section 48, which is the right conferring provision in the patent law, it actually makes a distinction between product patent and process patent, and it talks about actually an exclusive right to exclude others, not an exclusive right to do. Now, what is process patent? Let us try to understand with the help of an example. Suppose a company has come out with there are medicines which are available in the market, and this medicine can be produced by different processes, say process number 1 and process number 2. Now, a new pharma company comes out with a new process, and this process satisfies the patentability criteria. In that case, what would be actually the ambit of the patent right, what would be the scope of the patent right of that process patent holder? Now, let us go back to the previous slide. It says that the exclusive right to prevent others from using that process. So, nobody else in the world, if he has taken a PCT patent, or if he has taken a patent only in India, nobody in India would be able to use that process which have been patented for the purpose of producing or manufacturing the drug. Not only that, the process patent holder would also be would be able to prevent others from using a product that is actually produced following the process, the patented process he has developed. So, he can prevent others from using the process, and he can also prevent others from using, selling or offering for sale the product which is directly obtained by following the process which he or she has developed. So, this is the ambit of patent process patent in India. And now, what is in fact we now understand that in fact when someone gets a patent, a document comes to him, and this document is a grant of what you call by a government, and it actually gives the person, the patentee, a set of exclusive right, and he has the right to exclude others. At this point, we need to understand that what is the distinction, why it is not that you have the patentee does have the right to do, why it is being written that he has a right to prevent others from doing. So, why this provision has been casted in a negative manner instead of being casted in a positive manner. So, this can be understood with the help of certain examples, and I will be giving some examples. Suppose a person has come out with a patent, person number 1 has come out with a patent, and that patent is with regard to a chair. So, let us say that he has come out with a patent, that patent has actually a kind of claim portion with regard to the backrest and also a seating platform. Now, what happens, he can produce that chair and nobody else can produce that chair. Now, what happens, a third person comes out with an improvement thereupon. That improvement has a reclining feature, the back portion of the chair it can recline, and he also develops a further improvement that it does have a handrest. Now, the question is this, that if the second patent holder, if that patent holder is given an exclusive right to do things, he will be immediately doing things, but when he does this, suppose he actually he starts selling a chair with a backrest, with a sitting platform, with a handrest and also a reclining feature, he would be infringing the prior patent. And as a result of this, actually the patent right only gives the patentee a right to exclude others, from doing that, and if he wants to do it, he has to take a license from the prior patent holder. And that is the whole crux about why the patent provision is casted in a negative manner instead of being written in a positive manner, like he has the right to exclude others from doing. And we will find that if you look into the copyright law, you will find that section 14 of the copyright law, it actually gives a direct right to do certain things, whereas when it comes to patent, it gives a negative right to prevent others from doing certain things. Now, in the last class we have seen, actually this is what we have understood, that in one line if it can be described as patent law helps the inventor to internalize the externality of free riding by assignment of property rights. Now, what is the externality? What we have seen in the last class, there are twofold externality. Number one, once actually the intellectual property owner, he dispossesses, he has no other option except but to give up possession of his property, because if he wants to exploit economic benefit out of it, he has no other option but to disclose it to everyone. And we have seen there are twofold criteria. The criteria are, it is non-exclusive and non-rivalrous. So, it allows free riding by the person who has not paid the customary royalty for the intellectual property. And therefore, this actually this externality is actually an negative externality, whereby the property owner who is the intellectual property owner who has contributed to the development of the property, he or she would not be able to actually basically seek cost of production from those who are enjoying. And in order to actually prevent this kind of scenario, the government has assigned property right to plug in the negative externality. We have also seen that there are incentivization, and this incentivization is actually, we have seen threefold incentivization. For today's class, we will club the first incentivization and second incentivization to be the one and single, and the third one to be a separate set of incentivization. Now, the first incentivization is incentivization to invest. Now, incentive to invest, we will try to understand what does it mean, because in the last class I have put it in a bullet format. let us imagine a world where there is no patent law, and if there is no patent law, everyone would be able to actually make a product which has been made by someone who has actually given effort and energy and who has come out with a novel invention. Now, here in this actually example, we will talk about an hypothetical pharmaceutical company, and the name of the company is Messrs. Dhanvantari and Company. Let us say it is a famous pharmaceutical company, and it has spent, let us say, 150 crore in research and development of a new drug, and that new drug has the ability to cure asthma. Now, see, when Dhanvantari Pharmaceutical, they made 150 crore investment, they were not sure that whether this would be a success or this would be a flop. They were also not sure about the market, but they have taken the risk of investing 150 crore for discovering this new drug. Now, when after this, after getting a since there is no patent in the system, so Dhanvantari has no other option except but to directly market it, and Dhanvantari decides to sell a strip of 10 tablets at a price of 300 rupees. Now, these 300 rupees, let us assume that there are hypothetical breakups here, and this 300 rupee includes certain things. Suppose actually the 150 crore investment which Dhanvantari has made in its research development, they would be trying to recoup a minuscule part of that from each strip of medicine which is being sold in the market. For the time being, assume that it is 100 rupees. Then that is actually what they have spent for developing the drug, for developing the new medicine. Now, there is a cost of production, because they have to have the materials from which the tablets are being made, and they would be going for actually a kind of medical representative. Through medical representative, they will be doing a promotion of that medicine to the medical practitioners, and they will be also giving medical samples and all other. They will be distributing things to the retail medical shop, where from one can buy medicine by a prescription drug, and then obviously they would be also trying to make a profit, and a part of that profit can be invested in future for the purpose of further research. So, what you can see that this 300 rupees has different component. The first component is 100 rupees, whereby the company is trying to recoup the expense which it had made. Then 150 rupees is overhead, production and all other expenses, and then it is also actually making a profit of 50 rupees, and out from a part of that profit it is saving for the purpose of further research and development. Now, in that hypothetical world which we are trying to conceptualize, there will be in this world there will be no patent law to prevent the competitors of Dhanvantari from freely making and selling the same medicine. Suppose a competitor, he or she is clever enough to understand the formula and the composition of the new drug, and he has understood it, say, by reverse engineering, and then by reverse engineering, when he has understood, the competitor has understood the formulation, the chemical formula of the new chemical entity, it would start producing and selling the medicine, because in the absence of patent law, it would not be a violation of any kind of rights belonging to the first inventor, which is Dhanvantari. Now, since actually the first competitor has not made any investment in research and development, it would be straight away, it can do away with actually recovering 100 rupees from per strip of medicine, because it has made no actually R&D investment. Now, straight away the first competitor C1 would start selling the medicine at a price of rupees 200, and then if some third competitor emerges, that competitor, let us say that competitor wants to even sell it at a lesser price by reducing the profit margin, it can sell it at a price of say 175 per strip, and that way the fourth competitor can come up, and the fourth competitor can sell it by actually using a cheaper packaging and cheaper kind of bottle for the purpose of selling this medicine. And at one point of time, what will happen, the competitors, actually the public would be buying the cheaper medicine, and as a result of that, the price of the medicine would fall to a point at which the Dhanvantari would no longer be able to recover the R&D cost. Now, if this scenario happens, at first glance we think that this is good for all of us. Why it is good for all of us? Because as consumer we would be able to buy cheaper medicine from the market, and it is also good for the competitors, because competitors would be able to fully recover the cost of production which they are making. But what would happen? There is a long term there is a long run effect on the market. So, we have seen that actually since there is a patent system, that the Dhanvantari thought that there will be a kind of protection for its medicine, because this is a world without patent, and therefore, Dhanvantari thought that actually some kind of mechanism would be there to prevent the others from making. And because of that, keeping in mind the future, what you call future profit, Dhanvantari has invested 150 crore for the purpose of the drug discovery. And now, since the price of the drug has come down to such a level that actually Dhanvantari is not able to recoup the expenses it had made, therefore, it would stop taking a further endeavor for producing new drug, and it would create a serious lack of incentivization. So, now come back to what we have seen. This is the first economic rationale, that it is actually therefore patent, the presence of patent system is an incentive to invest. Now, we have now learned that the grant of patent right enables a inventor to recover the fixed cost. This is a fixed cost. This is the cost of production of intellectual property. So, the fixed cost for the production of an intellectual property in the form of patent, and which is basically incurred in research development, that patent system provides an opportunity to an inventor who is also an investor to recoup the investment what he or she has made. And thirdly, what we have seen, that without a patent, a competitor would be able to copy the product, because there will be no legal rule to prevent that competitor from actually using the benefit of the first comer in the market. And because of this cost advantage, the first comer, the investor would be out of the market. So, this stifles the development of new product, and in the long run the public, they would be in fact harmed by not getting new medicine for the, say for example, antibiotic resistant what you call infections and other things. So, no one would dare to invest money for the purpose of what you call developing new drug, and this is the first rationale which we have discussed which I have mentioned in the last class, I have elaborated in this class. Now, let us imagine a second scenario. The second scenario is actually why patent system is necessary. We will try to understand with the help of the second example. Now, here also we are trying to imagine a world without patent, and here the same manufacturer, it has learnt lesson from the first actually without a patent system. So, it has developed a very complex molecule, and this complex molecule is so complex, the new chemical entity is so complex that it cannot be deciphered, or it is near impossible to decipher the chemical formula of that composition. So, now that therefore, because now Dhanvantari is very clear about one thing, that by reverse engineering it would be virtually impossible for its competitor to understand the chemical formula of the new chemical entity. And after that they have invested, this time they have invested 300 crore to come out with a new drug that can cure fatty liver. And now learning from the prior experience, it decides to sell the strip of tablet without anyway disclosing its complex formulation. So, what would be the effect? There is a serious effect, and this serious effect is actually, instead of, because trade secret law is a law which in India which is governed mainly by contract law, if there is a contract, and if in the absence of contract it is governed by the common law, there is no codified law of trade secret in India. Suppose Dhanvantari has taken recourse to trade secret law to protect its invention, and it has not disclosed it to the public at large. And then what happens? When the new drug comes into existence, the competitors of Dhanvantari, they all come forward, they try to reverse engineer, because no rule will prevent them from reverse engineering the product, because there is no patent system. Now, after making several attempts, they have failed, and as a result of that, public is using this medicine for a long time, but actually they do not know what is the composition. And moreover, what will happen, that see, so far as patent is concerned, it is actually the period of protection is only for 20 years, and starting from the date of application for a period of 20 years, the patentee would be enjoying the exclusive right to prevent others from doing things under section 48 for a period of 20 years from the date of application. But when it comes to trade secret, it would remain a trade secret so long a competitor is able to reverse engineer and understand it. So, it may happen that the formulation would be secret, would remain secret in perpetuity. Now, what we have seen, that actually the very nature of intellectual property or inventions which are happening in today's context, they are incremental in nature. Think about the famous statement which Newton had made. Once he said that actually I am Newton because I am able to see beyond what my predecessors have seen, because I could stand on the shoulders of the giants, and therefore, I am Newton. So, this is actually absolutely true in today's context also. All knowledge, all technological development are incremental in nature, and it is actually premised, it is structured on the pre-existing notion and pre-existing understanding. Where my predecessor has left, I will start therefrom, and that way the society is getting benefited, because the patent system is actually, it allows a subsequent scientist, subsequent patentee to stand on the shoulders of the predecessors. In the patent context, it is called the inventing around an existing patent. In the absence of the knowledge of the formulation, what will happen? The member of the general public, or those who are interested to understand it, they would not be in a position to invent around, and as a result of that, the progress of technology, the march of civilization would stop. So, what is the rationale? Therefore, patent law in fact actually is a kind of incentive to a person to disclose. In the absence of patent law, he would not be disclosing. So, patent law in fact actually performing the function of preventing others, preventing an inventor from keeping his invention secret. So, and now what it does, not only it does have disclosure norms. To be very precise, what is disclosure norm? Disclosure norm means actually the invention has to be written down in a patent application, followed by claims, and that patent application, the patentee is required to actually explain it in such a manner, so that a person who is knowledgeable in the relevant field of technology, by reading the patent specification, he or she can make or actually make the relevant technology manufacture the patented product himself. So, this is the contribution which patent system has made. Now, therefore, patent system is a response to the trade secret, and what is this also justifies the second economic rationale. So, what is the second economic rationale? Second economic rationale, what we deduce here from is this, that patent law may be considered as a response to trade secret law. In fact, this is actually one of the important rationale of patent law. So, at the end of the day, the question is this, that actually whether patent law, does it actually lead to progress of technological development, does it lead to progress of what you call civilization? There are two views in this regard, and I will conclude with those two views. A great American economist, when American patent law was being drafted in 1952, an economist who was a renowned economist who was working on the patent system at that particular point of time, he was asked to comment on the new patent law. Then what he said is very interesting, and we do not know the answer even today. What he says, that what he said is actually, if you do not have a patent system, please do not try to have one, and if you do have a patent system, do not scrap it. So, what does it mean? Does it mean that technological development is patent law neutral? We have no idea about it, but see, the patent law performs a important role in creating incentive for inventors to invest in ventures that can lead to blockbuster inventions. Thank you.